All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here on CV21 0704 Oberg v. Oberg. As you know, we record and live stream these proceedings, so please give your name and the name of your client before you begin. You'll argue from the center podium. You each have 20 minutes per side, but of course you're not required to use all that time, and we do require you to keep track of your own time. The clocks on the podium will reflect the time you have remaining. Keep in mind that we have read the briefing, we've studied the record, and we've discussed your case in conference, and with that, you may proceed.
Thank you, Your Honor.
Good morning. My name is Christina Hamilton, and I represent the appellant Margaret Oberg. I think that if you've already read all the briefing, you know that the facts are essentially undisputed. Their husband admitted that wife was unable to support herself on her income. Husband admitted that wife got no compensation or consideration for $170,000 worth of real estate. Wife was in a stressful and in an addiction issue at the time. She was under psychiatric care, and within 10 days of signing the postnuptial agreement, she went to the Meadows for approximately a 6-week stay, and during that time, while she was in the Meadows, husband served her with the divorce. So the context is clear that the minute that the document was signed, wife, who was not in a good frame of mind, went to the Meadows, and husband filed for divorce. The law is obviously that the husband has to show that this agreement was fair, and that's like a threefold test, because not only do we have harbor, which is the three-pronged test for a postnuptial agreement, and that has to be that it was entered into voluntarily without duress or coercion, with knowledge, and that it was fair and equitable. But we also then have 25-317 and the Sharp case that mandate that the court make a determination of fairness. And even in the first appeal, the decision from this Court of Appeals was clear that the Superior Court is duty-bound to distribute the parties' property in a fair, just, and equitable manner.
Are you challenging the knowing prong of it, that it wasn't entered into?
There was no disclosure or any kind of information provided to wife, but I can't say one way or the other whether there was lack of knowledge.
And it did go back. We sent it back initially, and that was not raised as an issue. Was it just pursued on remand on the basis that it's not fair and reasonable?
Well, on remand, the Superior Court judge found that her job was to make requisite determinations, and so she was given the duties, she thought, of looking at harbor and determining whether it met the harbor test without any specific of whether it was knowledge, whether it was fair and equitable, whether there was coercion or duress.
But
I think she focused on.
But did your client argue at that point that it wasn't entered into knowingly? Was the argument just it's not fair and reasonable at that point?
Pretty much, yes.
And just curious, I understand the burden is on husband, but no request for an evidentiary hearing at that point, or was there some indication, like the value of the marital residence that was in the record?
So I think you're talking about when we went back on remand.
Yes.
And the judge, Jackie Ireland, at that time said, I think I have all the facts in front of me that I need to make a decision as to whether or not this postnuptial agreement, AKA now, will it be a part of the decree, is fair and equitable, and so I don't need any additional evidence. If I do need it, she said, I will let everybody know, and we will set a further hearing. So in her mind, it was just for her to review both the appellate level as well as the Superior Court level information and make those determinations.
But isn't there an opportunity to argue at that point where you need some more information? We need to know the value of the residence, whether there was any equity in the property? Well,
that was stated in both the postnuptial agreement and in the first decree. Husband stated that the value of the equity in the residence was $120,000 and the value of the equity in the lot was $50,000. So that was undisputed. And I think that's what the judge was saying. The facts were undisputed, so now I just have to decide if the facts support enforcing the postnuptial agreement as the terms or not. it's interesting that the husband not only cannot meet any of the tests, but he doesn't even attempt to argue fairness in his briefs. The only thing that he argues is that the potential of reconciling the marriage constitutes the consideration that makes the agreement fair. And there's cases that I've cited to you that suggest that that is not sufficient consideration, including the Whitmore case, in which the husband said, I'll stay in the marriage if you sign this agreement, and then of course he didn't, and he argued on appeal that she got the benefit of that, and the court said, no, that is not sufficient in order to enforce the postnuptial agreement. In the original appellate decision, the court stated words to the effect of 25-318 and 25-319 don't have to be the baseline, if you will, or words to that effect. And while I appreciate that was in there, it seems that there has to be some demonstration of, or some place to start on the issue of fairness. And under those two statutes, this agreement cannot even be potentially determined to be fair. Again, husband admitted wife could not support herself, so she was clearly a spousal maintenance candidate. $170,000 of equity in real estate with no consideration is not being demonstrated at all in husband's briefing or below in the court. The case law I've cited advises that postnuptial agreements are given a lot more scrutiny than other kinds of contracts, primarily because of the close and confidential and fiduciary relationship between the between the spouses. And I think that the court below a little bit got caught up in the contract law principles by saying, well, it says right here she signed it, that she understood it, that it's fair and reasonable, that she read it, blah, blah, blah. But Austin says, no, we don't stop there. We don't even look at that. What we're looking at is the three-pronged Harbor test. And contract principles don't supersede Harbor. And so they said, we're not going to go against the Supreme Court of Arizona. They said Harbor is applicable. And so that's what we have to be looking at, whether the agreement is able to meet the three-pronged test. I've also cited cases to the court where it is clear that when there are signs of overreaching, that is determined to be fraud for purposes of setting aside contracts. And in this case, not only did husband receive $170,000 of real estate for which wife got nothing and no spousal maintenance, but he knew at the time she was under psychiatric care. He knew at the time she had addiction issues, and within 10 days she's in a mental facility. And while she's in the facility, he then serves her, and their entire case seemingly is, well, the reason that she signed this was because of marital misconduct, and if she was promising she wouldn't do marital misconduct anymore. Again, that's not appropriate consideration, but even were it consideration, there was no marital misconduct demonstration of any kind between the time she signed and the time husband served her with the divorce papers. So that is just a red herring argument, in my opinion. Clearly, there was no consideration for the agreement. I've cited many cases to the court where there has to be a benefit and a burden in order to have a valid contract, and husband had no burden. I mean, he got 100% the property, he got away with spousal maintenance, and she got nothing in exchange. And the court below keeps saying, well, she got the potential to reconcile the marriage. Again, I've cited the Whitmore case, which says that doesn't constitute consideration, but more to the point, did she really get that? Because 10 days later she's in a mental facility, and while she's in there, husband serves her with divorce. So even if that were allegedly consideration, it seems very illusory because it didn't demonstrate in the facts. He filed for divorce immediately.
Would it be different if he had waited a year to file?
I don't know, but I think because
I'm just trying to figure out, is 10 days, if 10 days is enough, what is?
Right.
How do we draw a line with what you're arguing?
Well, two things. One is he'd still have to meet the fairness test, regardless. But second of all, I guess you look at the facts in that year, and if they were really trying to reconcile the marriage, and if she got benefits from being in the marriage, then perhaps, maybe it could be. But in this case, there was no reconciliation whatsoever. And so there's just zero facts upon which you could say, wife got some benefit for signing this contract. The court below also said that because wife got $450,000 of assets and husband got the requisite other half, $450,000 of assets, that's valid consideration. And again, since husband got got the same thing, 50%, and then got the real estate and the lack of spousal maintenance, I don't think that that is fair justification for wife giving away her statutory rights. Husband also cites the Dunbar case, the Arizona Dunbar case, and I think that has to be distinguished in three ways. First of all, it was pre-Austin, and the Austin case now tells us that any contract signed by spouses that affects their property rights has to be considered under the Harbor test. That was not a part of Dunbar. The second thing is, in Dunbar, they had gotten divorced. They had a division of their property. They got married again. Now they're going through their second divorce, and they agree within that framework that they'll treat all of their property as community property. And so the court said, well, okay, then you all agree that's consideration. You both put your property back into the pot. That didn't happen in this case. There was no benefit to wife or burden to husband. And the third thing is that the Dunbar case only argued the issue of duress, whether the wife was under duress when she signed, as opposed to whether the contract was fair and equitable. Husband's got some arguments that certain legal principles mandate the dismissal of the appeal, but I don't know that they are even applicable to the current situation. First, husband claims that wife has waived a fairness hearing, and I understand the argument to be either that she waived a fairness argument when she came before the Court of Appeals the first time, and not saying, Court of Appeals, you just totally throw out the postnuptial agreement and determine that it's unfair. We don't need to have that happen at the Superior Court level. And or when we went back on remand for failing to ask for an evidentiary hearing. I don't think that either is applicable. The first time that we were in front of the Court of Appeals, it was under a Rule 85 motion to set aside the default decree that had been denied in the Superior Court. The Court of Appeals said, no, we are setting aside the default decree, and then remanded and said, go back and have the court make the requisite findings that it didn't make under Harbor. When we got back to the Superior Court, the judge again said, I think I've got all the facts, no one's disputing the facts, so I just need to make the requisite legal determinations. So there was no waiver of an evidentiary hearing. The second thing that she says is the Court of Appeals could have just determined it was unfair from the get-go and set it aside. Again, under Rule 85, I'm not sure the court had that authority, but whether it did or not, it determined that instead of doing that, it was vacating the decree and remanding for the requisite determinations to be made. That cannot be a waiver by wife of a fairness hearing. The next thing she says is there's boilerplate language that, wife read the contract, et cetera, et cetera. Again, under Austin, the court says that's not good enough. We have to go through the three-pronged Harbor test. She says people sign postnuptial agreements all the time. Again, that's not, you can't use a blanket statement to look at a specific contract. The court has the duty to determine if this specific contract was fair. And the other thing she says is, the court below, she just put the word fair in the decree in various places without making any determination of how it was fair. And that's very problematic because she can't tie it to anything. Next thing, husband's...
So, just do we reverse and remand for the trial court to say how it's fair? Or are you saying as a matter of law we can resolve it?
I think as a matter of law you can resolve it now, because now we have a decree that is totally unfair. We're not asking to set it aside under Rule 85. We're saying that there was no evidentiary basis to determine that this postnuptial agreement was fair. Therefore, it should be vacated, and there should be a trial on the merits sans the postnuptial agreement, because no one has determined how it could be fair. And there's not even an argument from them how it is fair, other than this potential of reconciling the marriage, which I believe this court can determine is not appropriate consideration for the contract. Husband argues also that either cases about law of the case, or it should have been, if it wasn't brought up before, it can't be argued now, should apply. I don't think any of those cases are applicable in the instant case. In the instant case, the first time we were in front of the Court of Appeals, the sole issue the court decided was that they vacated the decree and remanded for requisite determinations. It didn't make any legal decisions other than vacating that particular decree. So there's no law of the case that the court has determined that we are now trying to get around. It was simply, you go back to the court and have them make the requisite determinations. Similarly, she says that if we could have brought it up before, we can't bring it up now. I'm not really sure how that's applicable in this case because the issue has always been that this rule, that the postnuptial agreement is unfair, and how it now is being incorporated into a decree is inappropriate under Sharp and 25-317. And none of that has been determined by any other court other than the Court of Appeals saying, yeah, we're vacating that decree. So there's really no law of the case or some issue that was already determined and now we're trying to go back and redetermine.
When we send it back, does the Superior Court have to hold a new hearing on spousal maintenance?
I would think it'd have to hold a new hearing on everything.
So why wouldn't it also include the fairness issue? Let husband present, you present, and resolve that.
Meaning husband presents.
You're saying the Superior Court didn't make enough findings to support the fairness, and so I'm still struggling a little bit with why we wouldn't just reverse everything and say, here, fight it all out again.
And that would be a way to do it. That's what I was arguing the first time we were up here on appeal. The court below took the appellate decision to simply say, I just need to make the requisite determinations. So that could be one way to do it. I also think that at this point, it is so clear in the record that this court can determine that the possibility of reconciliation, which is what the court below said, is the consideration, does not constitute sufficient consideration, that there has been no demonstration of sufficient consideration, that husband could have had a hearing down below to demonstrate more of sufficient consideration, did not, and therefore there is no basis to enforce this contract in this case. But I do acknowledge to you that an alternative could be to send it back and say, have a full-blown trial, but as one of husband's defenses, he can raise the terms of the postnuptial agreement. Finally, because my time is going short, I just want to reiterate again that the husband's brief primarily relies upon contract cases, which Harbor and Austin say we're going to raise postnuptial agreement to a much higher standard. And then there was the issue of the child support, which in the record before the court in July of 2020, no one disputed that wife was making $12 an hour. No one disputed that. But the child support calculation was made based upon an income for her of $40,000, where there's nothing in the record to demonstrate that. And when we were back on remand, the judge's order was, give me exactly what the first decree was, but put these words, fair and equitable, and these words about the possibility of reconciliation into the order. So that was incorporated without any further discussion or evidence on it. Finally, we are asking for our attorney's fees on appeal. Husband is the party with the greater financial resources, and we believe that this postnuptial agreement and the continued attempt to enforce it is an unreasonable position. Thank you.
Thank you, Ms. Hamilton. Ms. Sells?
Good morning, Your Honors. My name is Amy Sells. I'm here on behalf of Michael Oberg. We have a lot of issues in the briefing, but I think that there is only just one central issue that is at the crux of the court's decision today. That issue is the determination of whether the family court erred in finding the postnuptial agreement is fair and equitable. To make that determination, I think we need to remind ourselves that the court is not engaging in reweighing the evidence. That job is the family court's job. And this court doesn't even necessarily have to agree with the family court's conclusion. Rather, the inquiry is whether there's sufficient evidence in the record for this court to uphold the family court's conclusion. And I think that the analysis, to begin the analysis, we would need to discuss a little bit about what these postnuptial agreements are. They are out-of-court settlement agreements that are meant to avoid disputes upon dissolution of marriage, and for that reason, they're going to contain provisions that are otherwise different than what the law would otherwise require, for example, under 25-318 and 319. And as with and so there's going to be an unequal distribution in these, just by nature of these contracts. You're going to have one party that makes out better than the other party.
But you agree there has to be an element of fairness?
Absolutely, there has to be.
And so how is it fair to not give wife any of the equity in the marital residence?
Well, under WIC, because I thought about this too, how do you determine fairness? Because the danger is that if you just look to the four corners of the agreement and you see, okay, one person got more than the other, the knee-jerk reaction is, ooh, this isn't equal, and therefore it's not fair. And so WIC says that we look to the totality of the circumstances. And so I think that what we need to do is look at the totality of the circumstances that surrounded the genesis for this postnuptial agreement and then its ultimate enforcement.
But the totality of the circumstances are she signs an agreement that allows her to remain in the marriage for a couple of weeks, and that was the compensation for losing any interest in the equity in the house? Are there some other circumstances that are relevant?
There are other circumstances that are relevant, and also I think if you take a look at the preamble to the postnuptial agreement, it doesn't say, it says in consideration of remaining in the marriage, and there is no duration, there's no term in the postnuptial agreement that says in consideration for remaining in the marriage for an additional year or an additional 2 years. And not to sound like a cheesy Netflix show.
Wouldn't that have made a difference if the agreement had said, and we'll stay married for a year? Then there would have been something that both sides were truly giving. Each side agreed not to if they were going to enforce the agreement.
I don't even know if as a matter of public policy that you can enter into those sorts of agreements to remain married for a particular amount of time. I mean,
it's not that you're agreeing to remain married. You're just agreeing that that is the length, and if it doesn't last a year, then this agreement doesn't apply. I think that's a fairly standard agreement, that people say, if you stay married for 10 years, then this happens and you're entitled to this much.
Yeah, it's possible that there could have been a provision that was added in there and it wasn't. But I think that that's just one facet in this timeline that we can consider, but there are other things that I think that should be considered too when we look at reasonableness. And if you look at the timeline, you'll see that at every juncture of this postnuptial agreement that Ms. Oberg, she had a seat at the table. She was advised of her rights as to this postnuptial agreement, but she never exercised those rights. And if I can just walk you through a little bit of that timeline.
Well, we're not interested, I don't think, at this point in whether she willingly signed the document. She's advised of her rights and she signs it, but that doesn't answer the fairness question. But let's say they sign this document and husband files divorce papers the next day. So the consideration was you get to stay in the marriage, he files for divorce the next day. Has she received some kind of consideration for losing equity in the marital residence and the other property?
She has received the possibility of reconciling, and yes, I understand that there was.
So that's worth half the equity in a house, to have the possibility for 10 hours, and then the spouse files for divorce. That's adequate compensation for giving up the equity.
Well, I think that's why it's also important to look at the other factors that were involved here, that she had the opportunity to negotiate the terms of the postnuptial agreement, and if she wanted to, she could have hired counsel.
But we're not talking about another agreement. We're just talking about the one that was reached. And so what are the factors that showed that she got something in return for what she gave up, to show that it's fair? She clearly could have negotiated something else. But we're just here to assess whether what was negotiated was fair and reasonable.
So the focus then is on the fact that what is it, roughly, she enters into this postnuptial agreement in October, and then roughly 2 months later, her husband then files for divorce. And so what sort of benefit did she receive within those 2 months under the postnuptial agreement? She would only have received the benefits of the marriage for the amount of time between the date that the postnuptial agreement was entered into and when the postnuptial agreement, or I'm sorry, when the...
And was there millions of dollars of income that remained community property that she received during that time? Is there something that we're missing? Because the only thing that seems to be in the record is she signs this, and 2 months later, or however long, she's out half of the value of the real estate that she otherwise would have been entitled to share.
Right. No, to my knowledge, there's not some big boon, but I would submit that is the risk that you take when you enter into these contracts, and that I think on the flip side, the argument would be that somehow Mr. Oberg, even though he wanted to file for divorce, he should have stopped himself from filing divorce in order to avoid this sort of an outcome. And I don't know that it is appropriate to say that folks can't file for a petition for dissolution when they want to do that.
Doesn't this case really highlight the difference between a prenuptial and a postnuptial agreement? In a prenuptial agreement, it's perfectly appropriate for a spouse to say, sign it or I won't marry you. And that's not coercion. Mm-hmm. But in a prenuptial agreement, we also don't get into the fairness of it. In a postnuptial agreement, it's still perfectly appropriate for a spouse to say, sign it or I'm going to divorce you. But it still needs, but in addition, then it needs to be fair. It just seems this is that case that just really makes that difference clear. And so tell me how because all I have is keep the marriage and the benefits of the marriage between the time they signed and he filed. Is there anything else that she got from this? So 2 questions. I'll start with the first. Does this really crystallize that difference between the two?
I'm sorry.
Does it really crystallize the difference between a prenuptial agreement and what we require for those versus a postnuptial agreement and what we require for that?
Correct.
Because as a prenuptial agreement, this would be perfectly appropriate. The second question then is, what else besides the benefits for that 2 months, or whatever period, some say 10 days, I think people go back and forth, and the opportunity to stay in the marriage, what else did she get? Anything?
Not that comes to my
And
mind.
do we need to ask the question whether just that is consideration in and of itself, that you agree to stay in a marriage, whether it's 10 hours or 10 days or 10 months? Is that adequate consideration as a matter of law, that I will stay in the marriage and that's your consideration, even if you don't get the extra $1 million or the lottery ticket that happened during that period of time when you get no other benefit? Is that consideration? Is that a question we have to answer?
Well, at the time that the parties were entering into the contract, there's nothing on the table in terms of the consideration means that you get to remain in this, the idea was that you could remain potentially in this marriage indefinitely. So I think that if the consideration was that you have the opportunity to remain in this marriage and reconcile, that is sufficient consideration. I also think that at the prior oral argument, we had a lot of conversation about consideration. We seem to have settled on the point that the ability to reconcile was sufficient consideration, and I think that if the court did not find that we had that threshold issue satisfied, that the memorandum decision would have focused on that as the procedural error.
Didn't we just set aside the default judgment? I don't recall that the decision said anything about how the matter should be resolved. We just said Superior Court got it wrong by entering a default judgment. How does that somehow create some ruling on our part about the merits?
The merits of the consideration issue?
Yes.
Yeah.
I believed that if there were some sort of defect in consideration, that might have been noted in the memorandum decision.
That wasn't, I mean,
And we
I know you
wouldn't-
talked about it at oral argument, but that wasn't procedurally how the case came to us. I mean, we weren't being asked in Oberg 1 to make any kind of determination about how the parties entered the agreement, only that they should have a chance to talk about that to the fact finder. Right?
Right. but
Okay.
then-
I mean, finish if you had something else. I wasn't
No,
trying to cut you off.
Sorry, I was just thinking about how Judge Thoma said, well, we can't even reach the issue of whether there is fairness here unless we first determine consideration. And I agreed, and so we got past the issue of consideration and then moved on to the issue of fairness, which,
But fairness involves an assessment of consideration. So I'm just not understanding how that decision could have somehow.
Are you saying that as a matter of law, that you feel like they were briefed enough on that issue in Oberg 1 that that could have been what they stood on in their decision? That there wasn't consideration here and therefore we're blowing up the whole postnuptial agreement? We're sending it back and saying there is no postnuptial agreement?
had they chose to do that, they could have, but
Okay.
didn't.
But didn't. Okay. Just making sure I understood. Thank you.
And I'm just kind of tease a point. I don't know that the argument is that there's no consideration. It's just inadequate. Would that be a fair assessment of how you understand the argument?
That's how I understand it.
Okay. So there was some level of consideration given. It's just it's unfair in the amount or the extent of the consideration. And maybe
that is
co-counsel, or your
that's not my
opposing
argument.
counsel can clarify that point, because I think it's an important one. But so I had asked your opposing counsel, do we reverse everything and send it back and say, look, Superior Courts, start over? You really start over. You take evidence on the fairness, take evidence on the spousal maintenance, take evidence on all of this and have a hearing and then come back to us as opposed to the way it was handled. Because we don't have a record of what everyone testifies. We just have kind of avowals from counsel as to what it was and what folks were perceiving as the value.
So you're saying the alternative would be to remand, go back to the Superior Court and have the Superior Court do yet another fairness determination hearing, taking additional witnesses. I think that is a better way to go, as opposed to just vacating and doing everything from scratch, because we did not have the opportunity. Now with now having hindsight, if these are the issues, and the issue is consideration, was there adequate consideration, and if we really need to dig into the timeline in terms of what occurred from the time that the postnuptial agreement was entered into and the time at which the petition for dissolution was filed, then yes, I think that an evidentiary hearing on remand is better, is more
And
narrowly tailored.
Fair if we reverse it, you're going to have an evidentiary hearing on spousal maintenance regardless. If we reverse, they'd have to, that would be part of the hearing as well. The court could say, okay, I'm going to do it all at once.
If we say
I'm sorry, maybe I confused you. And go ahead.
Yeah.
Now, if we say the agreement is not enforceable as to the stipulation that there will be no spousal maintenance, obviously the court would have to have a determination as to what the appropriate level of spousal maintenance would be.
Right. And also under WIC, the Supreme Court acknowledges that the family court, in reviewing these things for fairness and equity, has the ability to either outright reject or to adopt or to modify. So I would ask that if there is some portion of the postnuptial agreement that you deem to be fair and equitable, that you allow those to remain. And if there's some portion that you deem not to be fair and equitable, that those be.
What in your mind is a portion of it that is fair and equitable?
I think
As to the resident, the real estate and spousal maintenance, are either of those something that just remains no need for an evidentiary hearing?
No need for an evidentiary
Well,
hearing?
actually, if the parties stipulate to the value, the equity of the house, maybe there's no need for an evidentiary hearing. But is there some portion of the postnuptial agreement that you believe is reasonable?
Yes, I think the value of the house.
Okay.
I don't think that I have anything to add, Your Honors, unless you have further questions for me. I think Judge Goss may.
I'm trying to phrase a question, and it has to do with the spousal maintenance piece. And here's what the question is. Is there a severability clause in this at all? I don't think there is, but I just wanted to clarify,
Your
because
Honor,
in the
I'm not
absence of a severability clause, I don't know that we can do that, can we?
Under WIC, it appears that you can.
And just enforce part of it, but not all of it.
Correct. I'm sorry, I'm trying to think if I want to make this final argument, or if it's really going to gain me any points. I just think that, and maybe we can have a conversation about this, but it's sort of a slippery slope. You know, I understand that these sorts of agreements are not arm's length transactions, the sort of contracts that we typically see. But what concerns me, and I also understand that under WIC that the Supreme Court said that family courts, they do have the power to go in and take a second look at these agreements and either adopt them, which in most instances they should be adopted, or they can outright reject them, or they can modify them. And my concern is that that sort of power cannot be an unfettered power. There has to be, it can only be, in my mind, an exception to the rule, and that the general rule is that these things should be adopted, because otherwise what you run into is the possibility that the courts are stepping in and supplanting their ideas as to what fairness and equity is. And so what you might have is an incentivization for a situation like this, where someone like Ms. Oberg from day one says, I'm all right with this postnuptial agreement. I'm going to sign off on it knowingly, voluntarily, willingly, and then she goes through every single step of the process, going to Mr. Oberg's attorney's office and signing off on an acceptance of service. She's not at that time was not represented by counsel because she chose not to be represented by counsel, and she allowed the default to be taken against her not just once but twice, and at every step of the way she was giving the impression to Mr. Oberg that she was on board with the postnuptial agreement. And only when the default decree was entered against her, that's when she perks up and says, wait a second, I changed my mind. I don't think this is fair and equitable anymore at all. And so you have an incentivization for folks who, if anyone was coerced and misled and led on, it was Mr. Oberg, because he's thinking that he's entering into this agreement that's going to prevent a prolonged, divorce litigation. And here he is 3 years later, two appeals in. And so I
could have simply said, we'll divide all of the assets. You'll get half of the equity in the house and half of the equity in the other property. And he could have avoided litigation over that, which is certainly what would have happened had they filed for divorce that day. So I'm not finding that to be a
isn't there
sympathetic.
kind of a stopgap in there somewhere that we don't reward someone simply for changing their mind? I mean, if it had been if the agreement was fair, whoever's deciding that, but the party who is challenging it just doesn't want to be in it anymore, for whatever reason, that isn't a reason enough to call the whole agreement unfair. I mean, a buyer's remorse is certainly not an excuse for a recognition that something's unfair. In fact, I think you start out saying things can look unfair if you're just doing numbers. That would be easy. We wouldn't need a judge to decide if we just put asset up to asset. So things can look inequitable but still be fair if the circumstances surrounding it show the judge that it's fair. So aren't there, I mean, we only have a few seconds left, but aren't there stop gaps in there to say it's not just a buyer's remorse standard?
Stop gaps in the facts of
And how a
particular
court
case.
has to look at an agreement.
Yes.
Okay. All right. Thank you, Ms. Sells.
Thank you.
Ms. Hamilton?
Before you start, I want to jump in with a question.
Sure.
When do we judge fairness? At the moment of signature or at the moment of enforcement? Because if we were 10 years down the road, I think you'd have a tough time convincing us this was unfair, because husband had stayed married for 10 years. So when do we judge the fairness at the moment of signature or at the time of enforcement?
Well, I would suggest that probably you judge fairness at the time someone is asking the postnuptial agreement to become the terms of the decree, because that's when 25317 kicks in, that's when Harbor would kick in.
So in other words, if we were 10 years down the road, if this was signed in 2010, we might be in a very different situation.
We might be.
Okay, that's a very, nobody's really talked about it, but it occurred to me when I was listening to the argument. I'm sorry. Go
That's
ahead.
okay. But I think that some of the things that Ms. Sells brought up and the court questioned her about are very pertinent to be reminded, and that is, you asked something like, well, what if husband would have waited a year or something and then filed for the divorce? Or what if he would have stayed in the marriage longer than the 10 days or 2 months or whatever? The problem is there was no downside to husband. There was no downside. Ms. Sells said the consideration as identified in the contract was to remain in the marriage. Well, A, he didn't do that, and yet he got the benefit of the assets and the lack of spousal maintenance. The possibility of reconciliation, she kept saying he gets that, she said that over and over again. Well, number one, she didn't get it, so it's illusory consideration because it just didn't happen, and she's pretty much acknowledged that. But more to the point, what did she get for that benefit? She got nothing. And again, she just doesn't appreciate that that's the reality of what happened. The next thing I want to bring up is that you asked the difference between a prenuptial and a postnuptial agreement. And you're exactly right. And why is there such a huge difference? Because when people are married to each other, they have existing legal rights with regard to property, with regard to spousal maintenance. All of those things are there. And so when a court has to look at a postnuptial agreement under Harbor, they have to make a determination that for whatever reason, this contract is fair. This contract is fair. And all the judge below did is say, well, she got the possibility of reconciling her marriage. That's all she got. And the next thing...
Well, no next thing, because we're out of time.
Okay.
So thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course and stand in recess to reset for the next argument. Thank you.